Third point. Your Lordship has in this Act, as in other acts, a Section 4, which says that you cannot marry if you are related, if your age is below 18. What are those? Conditions of marriage. My Lord has exact counterpart provisions in Christian Act and Parsi Act. Conditions of marriage. My third point is, if you have conditions of marriage and you are requiring an affidavit to be filed that I satisfy all these conditions of marriage, the form is given. And if those conditions are found false, either spouse or even the outside world can challenge and get voidness or voidableness, as the case may be, then what is the purpose served with this prior objection? So now I'm on purpose, on just common sense. After 1 month, suppose I don't give a notice, I marry. After 1 month, everybody settle down. After 2 months, somebody said that these conditions are not satisfied.
No, who can? Who can approach the court then?
No, but even after, anybody can approach.
You have locus in a matrimonial.
Aggrieved
In a matrimonial, yes.
Only a spouse.
Only a
Cannot be a
spouse.
third party.
Correct, spouse. No, but I'm saying, if there is a fraud, if there is a fraud of a gigantic nature, today, my Lord is right. For variety of things, only the spouse can.
These are matrimonial, aberrations or offences which only the spouse is entitled.
Now, the point is, that's correct, that's correct. That's correct. That's correct. Now, my point is, I'm at the moment, what are you serving by this 5 to 9? Now comes the fourth point. I'll tell Lordship what you are serving. In actual practice, in reality, even in heterosexual marriages. Now let us forget same-sex persons. That's the fourth aspect. I have shown that this should be unconstitutional. It serves no purpose. But what is the purpose it is serving for the last several decades? It is serving, the word your Lordship, one of your Lordship just now used, patriarchy. Patriarchy includes patriarchy also.
It was created at a time when women did not have agency.
Patriarchy includes patriarchy also. There are some agonizing
women
cases.
Never had agency. Women did not have agency when these laws and these...
This is an invitation to disaster and violence. It's an invitation, come.
And if the object was to protect...
My spouse has no problem, but you please come.
On their personal law,
yes.
Then by requiring, you're virtually laying them open to invasion by society. By collectors and district magistrates and superintendents of police.
My spouse can challenge me anytime. But no, you please from the outside come here. Your Khap Panchayat will come here. Somebody will come in different form. Where is gunning for you? That is not possible. What is the point of all this? In the High Courts, the Lordship have sat here and there, must have handled enough habeas corpus matters, coming to your Lordships. Why do they come?
I think in one of the cases, I remember having said that this cannot be given. It will destroy the entire purpose of marriage.
We have the case in our written submission, we'll point this.
Then, the other aspect it hits is choice. Individual decisional autonomy, privacy, individual dignity. This can all be put together. These are all constitutional core values.
Of course.
2 minutes. At one place it is there. Yes. I'm sorry, 56. 47 to 55, I have finished just now. Come to 56. Yes. These cases, your Lordship may see at your leisure, are important. Just note the principle. Yes. Intimate decisions from non-consensual public scrutiny is para 56. I hope my Lords have got it.
Yes.
And in particular, marriage is dealt with by your Lordship Puttu Swami in that para given there. I've given all the paras 271, 297 specifically. Then, the right to privacy is not limited to private spaces but public spaces. It's been read, District Registrar need not be read. Navtej has been read fully, but just note the point. Then public-private divide is 58, fully covered already. That Mr. Rodgi did, leave it. There is an important phrase I've used, in 61, right to informational self-determination. That's Puttu Swami, para 248. Muthuswamy, para 248, right to informational self-determination. This notice and objection regime is directly the heart of it, Malas. And then, Malas, decisional autonomy is 65. That's the social context, Malas, including all the invitations to disaster. Malas, 67 is an important legal principle of proportionality. Kindly give me 30 seconds on 67. This honorable court has recognized the possibility of a systematic abuse of rights infringing measures and read that into an assessment of such a measure's constitutionality under the doctrine of proportionality. This is excessive. This is completely disproportionate. What is the need for this in proportion, Malas? Your Lordships, Malas, said in Gujarat Majdoor, state action thus leaves sufficient room for abuse, thereby acting as a threat against free exercise of fundamental rights, ought to necessarily be factored in the delicate balancing act the judiciary. Directly applies, Manas. Your Lordship is inviting by this objections regime. And then, Malas, equality I've dealt with, Malas, in para 72. It's a discriminatory regime. Discriminatory because only if you choose the SMA, and if your Lordship were to strike it down, please don't misunderstand, it's not to be struck down for same sex only, Malas. It's to be struck down per se for heterosexual and non-heterosexual. It, Malas, is the only act. Personal law acts don't have it. This is a direct Article 14, Malas. And Malas, I have given in para 80 a rather, Malas, pithy summary of proportionality. 5-pronged test, my Lord remembers. My Lord has, I've called it out, Malas. 5-pronged test is a legitimate state object, a rational nexus between rights infringing measures. That is the suitability test. Para 80, Malas. The rights measure should be least restrictive. That is the necessity test. Proportionality stricto sensu, that is between balance between the extent and severity of the infringement and the object the state seeks to achieve, and sufficient safeguards against abuse. Malas, it stops at B itself. If you add C, D, E, it is completely, Malas, violative.
In my last week's judgment in Media One, I've sort of developed on the proportionality doctrine which Justice Sikri evolved in modern day.
Modern proportionality.
And in Media One, we have tried to sort of further fine-tune it.
Least intrusive.
Least intrusive. Well, as I am done, I'm very grateful. One page at the end of some stirring words which your Lordship may or may not want to use. Just give it. This is really the heart of this matter ultimately, Malas. It's a larger matter than merely provisions. Is this correctly typed? Well, as I've given it in a bit of a hurry with some, I hope there are not some typos. Just see these 4 quotations very quickly, Malas. One is, this one, no, ye to nahi, no. Have you given it there?
Yeah.
Malas, you Lordship will leave aside the top, Malas, what we are seeking. Just leave aside the top. Come to the quotations. Why do you add without asking me? Malas, Oberfell and Hodges, it would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. These are the category like us who has said that why should you be entitled to marriage? Their hope is not to be condemned to live in loneliness, excluded from one of the civilization's oldest institutions. They ask for equal dignity in the eyes of law. The Constitution grants them that right. Whereas Oscar Wilde was a declared homosexual in an era when this was something very, very different. And he died, he was actually imprisoned for it. He fell seriously ill. And then he came out and he died. He put this, fellows, in alien tears will fill for him pity's long broken urn. For his mourners will be outcast men, and outcasts always mourn. He was talking in the context of men, Malas. And then, Malas, this is lastly, I have filed these cases. There is a case called Fitzpatrick.
Yes.
The House of Lords is, Malas, the final order. The dissent is what I've quoted in the Court of Appeal. This dissent was approved by the House of Lords.
I knew it.
In a reverse. I have come to a clear conclusion.
Dr. Singhvi.
I'm very deeply obliged. I'm very deeply obliged.
Filed a suit for defamation and lost on this ground.
Yes. 1 second. Sorry, I'm reading this one.
I am very deeply obliged.
We begin with the hearing. We begin with Mr. Raju Ramchandran. And by the end of the day, we would have completed with the submissions of Mr. Raju Ramchandran, Mr. Vishwanathan, Mr. Uttara, and Mr. Anand Grover. We take it 4 of you would complete by the end of the day. Thank you.